Welcome to the Federal Retirement Podcast. My name is David Rates from Benchmark Financial Group, and every month we discuss important topics regarding the retirement planning process for federal employees. This Lunch and Learn series is an interactive discussion where individuals can ask questions. To join these discussions live, you can register by joining our email list at bfgkc.com. Additionally, if you're looking for assistance to get your retirement on the right track, set up an appointment with us today. You can schedule an appointment online by visiting our website, bfgkc.com, or email me directly at david.rates@bfgkc.com. The contact information is also listed in the description. By setting up a complimentary consultation, we can review your financial situation and develop a plan to meet your financial goals. We hope you enjoy this topic and hope to connect with you soon.
Well, good afternoon. It's going to be a fun time frame here. We've got a great topic with really great questions and great speakers. So I'm Gary Rates. I'm founder of Benchmark Financial, and I'm with David Rates. He is the president of Benchmark Financial, and with Linda Marshall, who owns Marshall Law Services and offices with us. So we're going to talk to you today about legacy and advanced planning, or said a little more directly, wills and trust, and how they play a major impact in your planning. You're going to get a chance to listen to an attorney that practices this every day with her clients, and we feel we've got good questions. But if you have things you specifically want to talk about a will or a trust, now's the time to ask. So I'm going to turn it over to David.
Well, like Dad was saying, thanks for tuning in, everybody, and feel free to chime in with any questions that come to mind. But like everyone was saying a second ago, the topic of discussion for this month's Zoom call is legacy and advanced planning. So, what do you really need a will for, and what do you hypothetically need a trust for? So, what we have with us today, Linda Marshall. She's been working in our office for a number of years now, but Linda retired from the U.S. Attorney's Office in the Western District of Missouri, and she's been in private practice for several years now, working with us and our clients, and carved out a specialty after working for the federal government with estate planning. So we're lucky enough to have Linda here, and thanks for being here, Linda. All righty. So moving into some of the main topics to get started. So, it always begs the question, do I really need a will? Oftentimes we hear that come up in conversation. Does the state provide a will for me? So I guess, Linda, what's the first thought that comes to your mind when you hear the question of do I really need a will?
Everybody needs a will. The state has passed laws, every state, and if you don't have one, but the problem is what the state has provided is something the legislature drew up, and most of us don't want our private affairs ruled by the legislature. And that's exactly the same way in the estate area, because they are trying to provide something that will apply overall in many situations. So for instance, both Missouri and Kansas say that if you don't have a will and you have a spouse, the spouse will get everything. But if you have children, the spouse gets half and the children get half. This is a problem because a lot of people can't live on half. The spouse needs more than half, at least during his or her lifetime. So unless you want to leave everything at the discretion of the legislature, you should draw up a will yourself. I highly recommend that you don't do it yourself, that you consult a lawyer, because the law regarding wills is very old, goes back to, the dark ages. And there are very specific requirements. Now, there are ways you can get around it, but basically it's going to cost a lot of money, because you're going to have to end up with going to court, and you don't want that. So by drawing up your own will with a lawyer's help, you can provide exactly what you want for your spouse, for your children, And for anybody else, for a charity, if you want to leave something to charity, if you want to leave, like Leona Helmsley had, a huge amount of money to your dog, you can do that. It's up to you, and you can be specific exactly about what you want.
So Linda, how would you define a trust? And I mean, 1,000-foot up view, how does it really differ? What's the main difference between a will and a trust? Because, you know, oftentimes your mind kind of gravitates towards a trust is for high net worth individuals and not necessarily for, you know, John Q. Public. What are the things that come to mind when you hear that question?
Well, a trust does apply to the very wealthy, but it also is very beneficial to the not so wealthy. If you have an estate, if you have assets that you want to be regulated in a certain way, a trust is the best way to do it, because it applies not only after death, but it applies during your lifetime. So if you become disabled and unable to handle your own affairs, if you become incapacitated, whoever you've appointed as trustee, as a backup to yourself, it can step in and handle things for you. This is an invaluable benefit. Another benefit is that with a trust, if you have put everything into your trust, all your assets are controlled under the trust, you don't have to go through probate. A will does have to be probated. And that is for two benefits, really. I mean, first of all, probate is generally viewed as, oh, we have to avoid probate. There are some very good reasons for probate. The first is to make sure that what you provided in your will be followed, that will be the way things are distributed and by whom. It also makes sure that your bills are paid. If, like most of you, you end up with expenses at the end of your life, you're not there to pay those, but whoever is handling your will will make sure that those are paid. The court will make sure they're paid in the order specified by law. With a trust, you can provide exactly who is going to handle them and how. Your trustee can act for you separate from any court intervention. It's like a contract where you say, I want my assets to go in this way and to be handled by this person at this time. So with a trust, you can say, you know, I really don't think if I pass away when I have kids who are in college or early 20s, that I want them to have sole control over however much money it is, hundreds of thousands of dollars potentially. Because, you know, Johnny might just think that while he needs a car to get to school and work, he really needs a Maserati to do it. And your trustee would probably say, Johnny, you can get a used Ford, and that'll be good enough for you to get to and from where you need to go. And a whole lot safer, frankly, in the trustee's opinion, probably. So you have much more control in a trust over how things are distributed. Under a will, things will be distributed at the time of death, how things were, and they'll be distributed then, unless you set up a trust in your will, which is an option, but it's more complicated. So by having a trust, you can be very specific about what you want, how you want it done, how you want it handled, and by whom, and make it a unique situation for your family and for your assets.
I think we were having that conversation yesterday. Does everything need to be split equally? It's not necessarily, you know, an even split. It needs to be fair given the circumstances of everybody's unique situation to a large degree. So
what I read several months ago has stuck with me. And I tell people this, that you should love your children equally, but treat them uniquely. What are their special needs? If you have a child who is wealthy in his or her own right, they probably don't need as much as someone who is struggling financially. If you have a special needs child, someone who has some physical or mental disability, they probably need more than your children who are doing quite well physically and financially. So, love them equally, but treat them according to their unique situation. And be frank about that with your family so that it's not a surprise, so that Johnny, who is quite well off, isn't expecting to get the same amount as Susie, who has some special situation. So, tell them up front so that people aren't unhappy, but treat them in what you believe is the best way for their unique situation.
Linda, let's say I set all that up and then I want to change it. How hard is it for me to change an existing document that I have? I created my will 25 years ago.
It's very easy to change either a will or a trust. All you have to do with a will is a codicil. It's an amendment, but they call it a codicil. And it's not you don't need to redo the whole thing. You can just say, I want to change this section in this way, but then you do have to sign it and execute it with witnesses the same way as you did your original will. With a trust, you just do an amendment. And it's the same process. You just change that particular section. Say, I want to change section such and such to be this instead of the way it was before. And because a trust is like a contract and not having all of the requirements that a will does as far as execution, it's just signed and witnessed.
So Linda, obviously, I mean, when you're talking about, legacy planning, will is a big piece of the pie. A trust is a big piece of the pie in terms of getting your assets where they want to go. But what are the other main pieces of putting together an estate plan when it comes to, what do I want to have happen if something happens to me medically? What do I want to have happen, with financial directives, given certain circumstances? Can you elaborate on that a little bit?
Sure. Powers of attorney are an essential part of an estate plan. You can have your general durable power of attorney, which is for financial matters, and that lasts until you pass away. Once death occurs, your powers of attorney expire. Unlike a trust, which is continuing on, and unlike a will that only starts when you die. So the power of attorney is there during your lifetime. And what it is a document that says, if I can't speak for myself, whether I'm incapacitated, whether I'm out of the country, out of town, whatever, then I have appointed this person to act for me. And you can specify in the document whether you want it to be for all purposes or very limited purposes. One thing that I like to do for people who have children is a limited power of attorney for childcare, so that if someone is out of town and has their grandparent taking care of the grandparent can take care of them, because otherwise you have healthcare issues and such as that. So, you can be very specific with the purpose of powers of attorney and make it accomplish just what you want to for the period of time you want to. A general durable power of attorney is for life, and it gives the designated powers to your agent. A healthcare power of attorney also is for life, and it gives your agent the powers that you specify as far as speaking for you in healthcare matters. So if you're not able to communicate your healthcare wishes, your person appointed as agent in the durable power of attorney for healthcare can speak for you. Now, you don't have to be able to speak clearly like we are today. I mean, you can indicate what your healthcare wishes are by as small a thing as blinking. Your medical professionals will try to communicate with you and get your wishes, even if it's limited to blinking. Blink 2 for yes, blink 1 for no, and they will ask and direct that. And they'll make sure that you're not just blinking because you need to blink. But that is for when someone can't speak for themselves or doesn't want to, because sometimes you run into a situation where somebody just doesn't want to make the decision themselves. They want it to be left to the person who has the power under their power of attorney. The next thing that comes under that is a living will or an advance directive. That is where you have specified ahead of time, if you are unable to speak for yourself, what you want done. This arose out of the Nancy Cruzan case years ago now, where she was in a coma for years and years. And there was a fight basically between her husband and her parents. Her husband wanted to pull the plug. Her parents did not want to. And kind of as a side, he had a new love interest. He wanted to get remarried. So it would be a lot easier if she was not living. But anyway, the living will advance directive says what your wishes are, what kind of care you want if you are in a coma, no likelihood of coming back out of it. And it's that type of situation. A subpart to the advance directive is a dementia directive. This is a separate document that tells your medical people what your wishes are if you have dementia. The one I use has 3 columns. One, if you have mild dementia, what your wishes are. One, if you have moderate dementia, and one, if you have advanced dementia. And it addresses where you want care, what kind of things you want done, what medical care you want. It's a rather new thing, but with the statistics on dementia these days, it's a good thing to think about and to have conversations with your loved ones about what you want done. The next thing that's shows on the slide there is a HIPAA authorization. That is a part of your healthcare power of attorney, but I like to use a separate standalone HIPAA authorization because you can give that to your medical people and not have to give them your whole power of attorney. In it, you specify who you want to have access to all of your medical information. A digital asset authorization is another document that I think is very important, especially in the last decade or two.
Yeah.
Because how many of us have digital assets? I mean, I think everybody does. And that's not just thinking of something that you have that's, like if you own copyright things and such as that. A digital asset is anything that you have that is in electronic format. So in other words, I have a bank account and I have electronic authorization to use my bank information. If I don't give authorization to someone, to my husband, he couldn't access that information because he's not the owner of the account. And the same with all of these other things we set up digitally. If you think about it, how many times have you gone online and set up an account and they say, read all the terms and conditions, how many pages, single space, crammed together. Do you accept and agree to all these? Well, who reads it? And you just automatically say yes and go on. You get the account, you can access your information and do business on the account. Well, buried in there is something that says it's only yours. Nobody else can access it. This became a really major issue for a family whose son was killed overseas in the service. He had kept online a diary, all of his pictures, everything he had online. When he was killed, his family wanted access to that. And the owner said, no, that's only his. Nobody else can get it. They had to go to court, file suit to get it. And that requires not just hiring a lawyer and the time to get to court and such as that, but it also requires notice timely so that the company maintains it. Because normally there's a time limit to where they don't maintain information anymore. So with a digital asset authorization, all you have to do is provide that, say to Microsoft or whomever, and say, I am authorized to have access to this. The last additional item that I want to talk about is an anatomical gift authorization. And this, we all know about the back of your driver's license where you can say, I want to be a donor. Well, that's fine, but it's just that. The anatomical gift authorization actually says what you want to donate, to whom, for what purpose, and then what you want to have happen. In other words, after donation, what's to happen to the body. Some people want to donate a very specific thing, and they can. They can donate just the skin. They can donate eyes, whatever. It's up to the individual, and you can specify that. Some people want to donate their entire body for research or any other purpose. You can specify that, and it will be honored, whatever you have said you want done and by whom. So we had a client here who had long-term polio. She wanted to donate her body because she lived into her 80s, which is extremely rare, with an early polio diagnosis that was severe. She wanted to donate her entire body to a certain medical facility for research on why she was able to live so long. You can be real specific, or you can just be general. You can say, I want to donate anything for whatever purpose is authorized by law. So it's up to you. Like all of these things in the estate planning area, you have control if you choose to accept it.
And if I have a will and a trust and I want to add directive, for example, do I have to start all over, or can I just add that, or how? I mean, as quickly as you can kind of outline it, what do we have to do?
If what you have now in your plan is what you want, but you want another thing, like you want a dementia directive, because that's.
Or pictures of all the pictures I have in my cell phone.
Right, your digital asset authorization.
Yep.
Those can be done standalone. You don't need to do anything else than what you want.
How about any other questions, Patty? Or just in general? Anybody have any questions at all?
There's none in the chat box, but feel free to unmute and ask or type a question in the chat box.
How do I get started? Do I have to fill out a lot of information, or how do I get started?
Well, the thing to do to get started is to call or email and make an appointment. There are a lot of a lot of information that's needed to get started if you don't have any planning done at this point. my suggestion is make an appointment, come in and we'll talk about it. And I'll tell you what information I need. It's probably, most of the information I need is probably what you've been thinking about and what you have on your cell phone, because we need, first thing that I want is to know what you want. And then we can go from there and get that accomplished.
Because it seems like oftentimes there's things that are feasible to put in a trust. I mean, if you're going down the road of a trust, you don't necessarily want to put all of your assets in the trust. I mean, oftentimes you hear people excluding cars and just certain assets like that sometimes morph into a little bit more of a headache to have in a trust than not so much. But like real estate and things like that, you see that in a trust quite often. So
I do not recommend putting cars in a trust. You transfer vehicles more often than
homes.
state most often. And there's a provision in both Missouri and Kansas on a title to say, I want this to be transferred on death to so-and-so. Both states also allow one vehicle to be transferred without going through probate. So I don't recommend putting cars in a trust, plus the fact that if you're in an accident and the other party sees that it's owned by a trust, they may think that you have a deep pocket and go after it. So that's my recommendation on vehicles. But anything else should be in a trust if possible. There's some things that if you have an LLC, you may not want it in the trust. If you have things with a beneficiary designation, those don't need to be in the trust. Although I do recommend that the beneficiary designation include the trust if that's appropriate for your situation.
Linda, how do you typically see people use beneficiary designations in conjunction with a trust? Because it seems like there's a little bit of confusion there.
With a beneficiary designation, if I have something where my husband's my beneficiary and I pass, my husband automatically will get that under that beneficiary designation. However, if I have children and have them named as beneficiaries, the children will take it right directly from that beneficiary designation, and it won't be under the umbrella of the trust, so that it doesn't have the protections that you've set up for handling the assets for your trust. In other words, you have something with a beneficiary and an account, financial account, you've put your children as the beneficiaries on it. You've set up your trust so that you want your children to get it at certain ages and certain percentages. You don't want them to get a whole big lump sum at 25. So if they get the property under the beneficiary designation, it bypasses the safeguards you've set up in the trust. So for that reason, there is a lot of benefit to having those type of asset situations pass under the trust instead of under a beneficiary designation.
We do have a question in the chat. Is there something different that would need to be done with federal benefits willed to an estate, and then the will transfers assets to trust for children, whether minor or adult in need?
Not sure I quite understand that question. If I'm understanding it, and if I'm not, let me know. But if it passes under the will to named people, including children, it's going to be handled by a guardian who's appointed by the court or that you have designated in your will. So that guardian would handle it, manage it until the age of 18 or 21. I think it's 18 in both Kansas and Missouri. But if you set up a testamentary trust, a trust is part of your will, you can then direct it to go in a trust situation. I have not heard of anyone saying, well, let me back up. You can provide in your will that you want everything to go to your trust. And that is a typical situation, in fact, that it's an alternative provision that you want everything to pour into your trust, called a pour over will, where anything that you haven't gotten transferred to your trust while you're living is to pour into your trust and then be handled as part of your trust the way you've designated it.
Unless it would be a beneficiary designation.
Right. If it's a beneficiary
Yeah.
designation, unless you said that the trust is the beneficiary,
Right.
then it's going to go to the individuals you've named.
And really, in terms of the federal stuff, the main things that would crop up would be, you know, what do you want to happen with your TSP money? What do you want to, if you have federal employee group life insurance,
Right.
what do you want to happen with that? The only one that is really somewhat unique would be like if you passed away as an active employee and you still had, you know, contributions that you'd paid into the FERS retirement system, those would get paid to a beneficiary. But in
Right.
terms of the federal stuff, the system's kind of built to leave it to a surviving spouse, and outside of like federal life insurance and TSP money, it kind of is set up for you. You don't really have too many options to do things outside. I mean, you do an insurable interest pension, but those are so rare because people have to take oftentimes a large deduction of their pension to leave it to an insurable interest scenario.
You can leave your FEGLI and.
And it's not uncommon for people to have, you know, outside life insurance policies in addition to FEGLI and outside investment accounts in addition to TSP. So
Yeah,
that's one where you kind of want to tackle everything at the same time and not do it piecemeal, you know.
right. You can leave TSP and FEGLI to your trust or to pass under your will. Probably you wouldn't have that. As long as you have your designations, beneficiary designations, it would not pass under the will. It would pass under the way you've designated, either to individuals or to your trust.
Any other questions, Patty?
There are no more questions. Oh, wait a minute, there's one. So beneficiaries would be the best way to go? In
It
adding to that?
depends. It depends. Yeah, if you've named people as beneficiaries who for some reason are not able to handle things themselves. So say you have a 10-year-old child and you've named them as your beneficiary. Well, they're not able to handle it themselves. And if you've named a 21-year-old son, he may not make the best decisions. And even if it's his, if he gets married and then puts everything into a house jointly titled and then gets divorced, then the spouse, soon to be ex-spouse, will get part of it. These are things that you may not want. And so if you provide in a trust for the money to be distributed at various stages, ages and such as that, you can protect against those type of issues to a certain extent, at least.
Or we were talking about this example yesterday. So like, let's say you have 3 kids and, you know, God forbid, child number 3 passes away, but they have a child of their own at the point that they pass away. Well, if it's just a beneficiary designation, then the 2 remaining children are going to split whatever's left over 50-50. And let's say hypothetically you wanted a portion to go to that grandchild.
Mhm.
You know, you can't necessarily do that quite as easily with beneficiary designation as opposed to a trust. So
Right.
it seems like the big thing is having some control from the grave, so to speak, over where money goes. And you really need to think, you know, long and hard about that, because it's a bigger deal than you think it would be. It's just sometimes people don't want to think about it until it's time to think about it. So
Yeah. And then the other thing is, if you have a special needs child,
yeah,
you don't want that special needs child, if they're receiving or applying for government benefits, to be disqualified by the gift that they receive from your estate. You can set up provisions for a special needs trust or subtrust where that won't happen.
Wait, Patty, is there another question? We can't.
She's muted.
Yeah, you're.
Here we go. If you set up a trust with spouse and one spouse passes, does the remaining spouse have to redo the trust?
I usually use joint trusts, and no, you don't have to redo it. It's the surviving spouse becomes the sole trustee, and depending on how you set it up, can either have full control or limited control over what happens from that point on.
Any others, Patty?
Okay, let's see. Yes, does a trust protect your assets should you need a long-term care facility in the future?
Long-term, your trust assets would be used for for paying for the cost of long-term care. Unless you have, well, if you have a long-term care policy, that's first. If it doesn't cover the full amount, then your assets, including assets from the trust, would be used to make up the difference. If you don't have a long-term care policy, you would be looking at the full amount to come from your assets, including from the trust.
Yeah, participating long-term care policy is really the only vehicle to protect assets from creditors in that situation.
Mm-hmm.
So, but long-term care has become a tricky beast in the last several years with interest rates being as low as they were, but we're entering new territory with interest rates. So
A good example of that is that the federal government used to have a long-term care plan, and they no longer have a plan available because so many of the companies have gone away from marketing the plan. So you have to be really sensitive and trying to find what there has to be resources to go find what you're looking for. And it's become a little bit more difficult, but not impossible to achieve is coverage under long.
I will say one thing to keep in mind about long-term care insurance is if you have it on the books and you've gotten a letter from XYZ company about a premium increase, that's not necessarily your only option. That's just like kind of like a cookie cutter option that a company gives you in a form letter. But you have more flexibility in mixing and matching certain variables if you call the company directly and go that route. So
Hey, it doesn't look like there's any more questions.
well, thanks for tuning in again, everybody, and hope to see you again in the future. And if you have any questions, don't feel free to give Linda a call or
David,
reach out via email.
Actually, somebody did just pop in a question.
Okay.
How would you determine a reasonable ballpark estimate of fees minus percentage of assets, flat fee, annual updates?
If you're talking about my fees for setting up an estate plan, I use a flat fee. Depending on the situation, when we meet, I can tell you what that would be. For a bank to handle the trust, if you're not able to handle it yourself and don't have another family member who's able to act as trustee, that depends. The bank and trust companies around town have various rates that they charge, and we'd have to look at that. It's based on the assets that are under management by them.
Which is usually the larger the asset, the lower the fee, right?
Well, the lower
Larger-
the percentage.
Yeah, lower the percentage, yeah.
Yeah.
Okay, that looks like it for questions.
Well, like we said, thanks for tuning in, everybody. And if you have any follow-up questions for Linda, feel free to reach out. Her phone number is listed above, or shoot Linda an email and go from there. Hope to see you in the future. Thanks for tuning in.
Yeah, thanks for taking time to listen.